Joining us now is FAMU Law Professor LeRoy Pernell to discuss a very serious and emotional topic, children and the death penalty. Welcome, Professor Pernell. It's always good to have you.
Thank you. I'm glad to be here.
First of all, is the death penalty still happening for children in our country?
Well, no, the United States Supreme Court has decided that an individual younger than 18 at the time of allegedly commission of the offense cannot be put to death.
Okay.
But that's relatively recent given the history of the death penalty.
And tell us about the George Stinney Jr. case and what happened to him.
Well, this is one of the great tragedies on so many levels. Now, here was a young man, a boy, 14 years old, when two who was black, two white girls went missing. He had actually tried to assist those girls in finding they were looking for flowers. And when they went missing, he voluntarily went to the search party and said, "Oh yes, I saw them," and tried to help them out. That fact alone caused him to be accused of murdering them. There was no evidence. There was no physical evidence. There allegedly was confession, but it was never clear that a confession ever actually happened. But this young boy was put on trial for 2 hours, and it took the jury 10 minutes to vote death for him. And he was executed. 70 years later, this was back in 1944, 70 years later, he's now been exonerated as the judges reviewed the case and realized that he was actually innocent of committing. This was an innocent child that was put to death for a crime that they didn't commit.
And why do you think stories like this, when we think about Emmett Till and George Stinney Jr., there are certain ones that stand out that are just engraved in our memories. How do you see relief for these families, and what can we do to honor their memories?
Well, I think what we can do maybe to honor their memories is to tackle straight on the injustices that are in the criminal justice system. The injustices that are very often linked to race. The fact that still to this day, African Americans are underrepresented in juries that consider the death penalty. One of the things that we know, that statistically we know is true now, is that a significant portion of individuals who are now freed by scientific evidence, by DNA evidence, a disproportionate number of those people freed are African Americans, which means that they have been sentenced for crimes that they did not commit. Very often those were death sentences. In most instances, those were death sentences. And what that points out is a problem in our jury system, a problem in our evidence system. A lot of those cases involve wrongful eyewitness identification that didn't take into account issues of race and how that might have influenced. It also points out a need to seriously address the issue of effective assistance of counsel. This young man, this boy who was executed, had a lawyer appointed for him. The lawyer never talked to him. And the lawyer called no witnesses. This was a child on trial for his life. No witnesses were ever called on his behalf. Now that's a stark example, but we have that problem even today. And it's not just an issue of whether or not the person has a public defender or not. I'm a former public defender. And I know that public defenders very often do an excellent job against the odds. But there are problems throughout the system, whether it comes from the public defender, whether it comes in terms of private attorneys, who need some cultural and racial competency in terms of how they represent individuals and understand all the dynamics that cause this system, our criminal justice system, to be disproportionately against African Americans. And we see that statistically. It's not just opinion. It's not just, well, you're overly sensitive. Statistically, we know this to be true. We know that if you control for the nature of the crime, you control for the prior record, and you take two individuals, one white, one black, identical in all other ways, The chance of receiving the death penalty is higher. The chance of disproportionate sentencing is higher. The chance of not being released on bail is higher if you are black. And it is it's an indictment of the criminal justice system, and it's a tragedy that doesn't have to continue if we were to address some of the underlying causes.
And I know we have to wrap, but as far as the juvenile programs for juvenile reform, is there a comment that you'd like to make about how things can be addressed on that level?
I think the juvenile issue is a particularly troublesome one because it reflects a cultural challenge that we have, particularly for African American children, and African American male children in particular. And it starts with the school systems, where you have disproportionate number of African American children who are expelled from schools, who are basically forced into the criminal justice system for offenses that are not necessarily the serious offenses that the public seems to think happens. It's not crimes of violence, it's not drugs, but vast majority of those individuals are disproportionately pushed out of our education system for nonviolent offenses, and it speaks to an attitude of society that young children, young black children, are somehow miniature adults.
Yes.
They're threats, and we don't nourish, protect, and develop them as children. And I think that is an underlying problem. If you take young black men and women and you don't help them develop as children, then you're going to reap a consequence that you really do not want to have to face.
Yeah, there's so much more on this topic, and thank you for taking time to share these things with us today, Professor Pernell. It's a lot to think about. Sobering.
My pleasure.
Yeah. Now we have a better understanding of the controversial George Stinney Jr. case.